I'm Lisa Moore and I'm the Chief Executive of the Devon County Agricultural Association. We've made this video to really help us understand how the changes in the law with anti-bullying and sexual harassment that came in October last year mean to us. With me today I have Trevor from Perspective HR and I have Roger, who's our employment barrister. Trevor, would you like to introduce yourself?
Yes, I'm Trevor Vanstone from Perspective HR. We work with over 80 organisations across the UK, everything to do with HR, employment law and leadership training.
And Roger, could you introduce yourself, please?
Yeah, sure. Roger Davis, employment barrister, been qualified for 20 plus years. I set up P4B Law Limited 19 years ago. We deal with all aspects of employment law, range of employers across all industries, and I have to say, we're kept very busy.
The first question I have to you, Trevor, is how can we discriminate about what's happening at work in this day and age?
Discrimination, harassment, bullying is basically treating somebody badly because of who they are. These laws are nothing new. They've been in place since the 1970s. In fact, some of these laws were in place when I was still at primary school. And of course, every employer in the country, and if you have volunteers and other people working for the organisation, all of these things are spelled out in their equality and diversity policies and their bullying and harassment and grievance policies. So all of these things are covered. Sadly, though, in our industry, there is still plenty of evidence that it goes on, even in this day and age.
And Roger, can we have your point of view, please?
Yes, certainly. As Trevor says, this legislation has been in place for a very long time. We've had this new change, which we'll talk about later, which came in October last year. Just from our own experiences and the reported cases in the employment tribunals, you'll see that sexual harassment, unfortunately, is still very prevalent in the workplace. And I think the changes which have come in over recent years and are expected to come in, and again, we'll no doubt discuss these later, demonstrate that perhaps the previous approach to dealing with sexual harassment hasn't worked, and we're seeing a shift towards the legislation putting the onus on employers to proactively prevent sexual harassment. And hopefully, certainly from all aspects, from employer aspects, from employee aspects, we're going to see that making changes in the way that the legislation and the case law is progressing, and hopefully we can start to address the numbers of cases that we see.
So Trevor, can you tell me who this video is relevant to?
In reality, everybody. It's all the managers and leaders at an organisation, but also every member of staff, not to mention other stakeholders, so volunteers, stewards, anyone that's involved in an organisation. This applies to everybody. Everyone has rights and responsibilities around this subject. I think it's fair to say that discrimination and harassment, from our point of view as HR practitioners, is the most dangerous thing that can happen at work. It's at the top of the tree in terms of legal danger. I always think the test, when I'm talking to a client about this, is okay, if that was my daughter, my wife, sister or son for that matter, being treated badly, how would I feel? It's also worth remembering it's not just the legal dangers and the costs at a tribunal, but it's the toxic environment that could be created if these things are left unchecked, the loss of productivity. And don't forget, people are not slow in letting others know if they've had a bad time at work.
Thank you, Trevor. And Roger, from your point of view, who do you think this video is relevant to?
I think at this point, it's probably worth just mentioning that discrimination and equality covers a huge area of protected characteristics. This video in particular, we are only looking at sexual harassment. And probably worth at this point looking at the definition of sexual harassment, and that is unwanted conduct of a sexual nature where the conduct has the purpose or effect of violating the employee's dignity or creating an intimidating, hostile, degrading, humiliating or offensive environment. And I think one of the important words in that definition is the effect of violating the employee's dignity. Quite often we hear employers and employees try to run the defence that there was no intent or purpose with regards to the comments or the behaviour, but the definition is very clear in terms of looking at the effect of the behaviour on the individual, on the complainant, rather than the intent or purpose. And as Trevor indicates, certainly we see too many cases with regards to sexual harassment. A recent 2023 poll by the TUC suggested that three out of 5 female employees in the workplace have suffered bullying, harassment, or sexual harassment in the last 12 months. And I think that the recent changes in legislation, which have come in October last year, are designed to put the onus on the employer to prevent sexual harassment rather than just treating the problem once it's happened.
And if a manager or a leader hears or sees a complaint, what is the best way to deal with it?
Well, we always say that leaders and managers are judged on how they handle the difficult matters at work. And the starting point is to look at the policies that you have and, of course, to take the complaint seriously. Take that person to one side, find out what is happening and deal with it. Neglecting it, delaying it, not holding a proper investigation is the most dangerous thing you can do following a complaint.
Thank you, Trevor. And Roger?
Absolutely. Case law is littered with criticisms by employment tribunals and employment appeal tribunals over the way that employers have dealt with complaints. Issues with regards to delays, issues with regards to not taking the employee seriously. There's one particular case I read a couple of months back where the employee made a complaint of sexual harassment and the manager advised her to take it as a compliment. And that inadequacy in dealing with complaints, in having that investigation, in sometimes finding that there is no sexual harassment, where the facts tell a completely different story, are areas where the employer is going to be punished if they end up in an employment tribunal. So sometimes it's about suspending the employee if there's sufficient evidence and the allegations are serious enough, splitting the complainant and the person complained about, splitting them up in the workplace if it's all possible. And it's about taking the complainant seriously. Don't judge their complaint based on previous history. Take their complaint, at least for the moment, at face value and deal with it accordingly.
And what about employees? What is their responsibilities?
Certainly from an employee perspective, I think a very important point, which is quite often overlooked, is that employees as individuals are personally liable for discrimination. And it's a commonplace tactic for employees who bring claims to name individual employees as well as the employer. And employees can find themselves on the wrong end of compensation awards. And as well as recognizing that as employees, they're personally financially viable, there's also an onus, on employees to do their part with regards to calling out sexual harassment in terms of not being a bystander, but standing up when is needed. And I think if as a workforce, as a society, we're going to address sexual harassment, then we have to recognize it's not just the job of the employer, it's the job of the employees as well.
Thank you, Roger. And Trevor, from your perspective?
Certainly, employees at work, I would say, have the right to step in and intervene if they see this thing going on. And of course, as an employee, you could be a witness to something like this, or of course, you could also be supporting someone, perhaps accompanying them to an investigation hearing around this. There's also a very interesting point around this in that sexual harassment, let's not beat around the bush, is the vast majority of cases are men sexually harassing women. And there is an interesting point around the role of other men if they witness this. And there is a feeling in the sort of HR and employment world that sometimes men may be reluctant to step in because they may be seen to be taking sides against other men. Or, of course, they may not feel comfortable, as it were, being a sort of shining knight riding in to rescue a woman at work. Personally, I think that would be a risk worth taking, and I think if you saw something like this, you would want to check in that that person was okay and deal with it.
Well, if I could just maybe jump in there, if I may, Trevor, and absolutely the predominant claims of sexual harassment by females against males. However, let's not forget it works both ways. There was a recent successful claim by a male employee against a female colleague where she had made comments about him having a fit body and seeing him in Speedos. And it works both ways. It's not only, even though it is predominantly a female area of complaint, it's also males are able to bring complaints against females. And also there was a recent case of a chef who's a male who brought a similar complaint of sexual harassment against another male. So I think we've got to look at it from a very wide perspective and not just from a female perspective as well. And finally, just on that point, let's not overlook the issue of victimization. This is where an individual brings a complaint of sexual harassment and is ostracized or treated badly by their colleagues or their manager. And again, the employer needs to be mindful of that where a complaint is made and needs to step in and address that if it becomes relevant. Because victimization, even if the original claim is unfounded, is a claim in itself. And again, something which shouldn't be overlooked.
So, Roger, could you let us know what the big change around sexual harassment is, please?
Yes, big change in sexual harassment came into force October the 26th last year, a fairly random date. And what that does is place the onus on employers not only now to deal with incidents of harassment, but there is now a proactive requirement to prevent harassment in the first place. And you might well ask, how do employers do that? And the guidance from the Equality and Human Rights Commission talks about having risk assessments in place, having regular training, and an important point just at this point to mention is that it's not a one-size-fits-all. It's about tailoring that training, looking at the risks from your particular organization's perspective. So whilst we're talking today in generic terms, it's something which needs to be addressed on the level of the organization, on the level of the business itself, to look at the specifics, the specific risks within the type of employees and the type of work you undertake. And employees, if they bring a claim of sexual harassment and they're successful, and the employer has not been able to demonstrate that it's taken reasonable steps to prevent sexual harassment, will have an increase in their award for compensation of up to 25%.
As Roger rightly says, the training and awareness for everybody in an organisation, which can include volunteers as well, of course, has to be done, and it has to be tailored for that organisation. There's no doubt that the reality of the risk around this subject, sexual harassment, will be different, for example, in the hospitality world to what it would be in an office or a factory, or even, any of the professions. And the critical thing, I think, particularly during induction and during regular training with staff, is to make people aware of this. And it's not a question of just delivering the training once, ticking the box, that's it. Anything over 2 years is regarded as stale. So it's important to be talking to your teams about this. It doesn't have to be a big formal stand-up PowerPoint or anything like that. It can be a workshop, it can be a discussion, but make sure these points are covered.
Thank you, Trevor. And Roger, do you see any more laws coming shortly?
Certainly with regards to sexual harassment, the government has indicated that it's going to seek to strengthen the rights of employees to bring claims against or claims in connection with third-party harassment. At the moment, it's difficult but not impossible for an employee to bring a claim where they've been harassed or sexually harassed by a third party. The question of whether they can bring a claim at the moment in general terms rests on how the employer has dealt with it. But going forward, the government has indicated that it's looking to bring in direct claims by employees with regards to third-party harassment. And also, it's looking to extend the definition and the obligation on employers. At the moment, employers have to take reasonable steps to prevent sexual harassment. In the future, the government is proposing that employers will have to take all reasonable steps. We don't know at the moment what that's going to look like, but for certain, there's going to be a greater obligation on employers. And that, of course, is just one element of the changes on the horizon. We probably haven't got time to get into those today, but the government is looking to bring in day one rights for unfair dismissal. They're looking to bring in additional rights for zero-hour workers and looking to strengthen in areas around maternity leave and a number of big topics, big changes in employment law over the next couple of years.
I think specifically on harassment, discrimination, I mean, all of these things sound very scary for people at work, but if you strip it back, it is ultimately about treating people at work how you want to be treated yourself. There is no room for bullies in the workplace. They don't achieve anything. Really, everyone in an organisation, whatever level they're at, whether they're the CEO, whether they are someone on their first day at work, has a role to play in this. People deserve a workplace where they're treated with respect, and everyone has a stake in this.
Trevor, thank you very much. That's really appreciated. Could you please explain to us how we can find any further information?
Yes, I mean, I think for any employee or volunteer or anyone affected by what we've talked about today, the first thing to do is to look in the employee handbook or the volunteer handbook. Everything is in there. Speak to a senior manager, get more information. And of course, there are plenty of other resources, for example, the ACAS website, or of course, the Equality and Human Rights Commission website.
Thank you, Trevor. That's really helpful. And Roger, is there anything else you'd like to add?
Just one little thing, I think, and that is, if you don't take anything else away from today, it's something which shouldn't just be looked at once. It's something which should be revisited over the years. There's going to be a lot of changes coming through over the next 24 months. And I think for certain it's something which employers need to keep on top of.
Thank you, Trevor and Roger. It's really appreciated taking the time today to go through these questions with us.